Rule 140. Charges against judges of first instance. Section 1. Complaint. All charges against judges of first instance shall be in writing and shall set out distinctly, clearly, and concisely the facts complained of as constituting the alleged serious misconduct or inefficiency of the respondent, and shall be sworn to and supported by affidavits of persons who have personal knowledge of the facts therein alleged, and shall be accompanied with copies of documents which may substantiate said facts. Section 2. Service or dismissal. If the charges appear to merit action, a copy thereof shall be served upon the respondent, requiring him to answer within 10 days from the date service. If the charges do not merit action, or if the answer shows to the satisfaction of the court that the charges are not meritorious, the same shall be dismissed. Section 3. Answer, hearing. Upon the filing of respondent's answer or upon the expiration of the time for its filing, the court shall assign one of its members, a justice of the Court of Appeals or a judge of first instance to conduct the hearing of the charges. The justice or judge so assigned shall set a day for the hearing, and notice thereof shall be served on both parties. At such hearing the parties may present oral or written evidence. Section 4. Report. After the hearing, the justice or judge shall file with the Supreme Court a report of his findings of fact and conclusions of law, accompanied by the evidence presented by the parties and the other papers in he case. Section 5. Action. After the filing of the report, the court will take such action as the facts and the law may warrant. Section 6. Confidential. Proceedings against judges of first instance shall be private and confidential. Rule 141. Legal fees. Section 1. Payment of fees. Upon the filing of the pleading or other application which initiates an action or proceeding, the fees prescribed therefor shall be paid in full. N. Section 2. Fees in lien. Where the court in its final judgment awards a claim not alleged, or a relief different from, or more than that claimed in the pleading, the party concerned shall pay the additional fees which shall constitute a lien on the judgment in satisfaction of said lien. The clerk of court shall assess and collect the corresponding fees. N. Section 3. Persons authorized to collect legal fees. Except as otherwise provided in this rule, the officers and persons hereinafter mentioned, together with their assistants and deputies, may demand, receive, and take the several fees hereinafter mentioned and allowed for any business by them respectively done by virtue of their several offices, and no more. All fees so collected shall be forthwith remitted to the Supreme Court. The fees collected shall accrue to the general fund. However, all increases in the legal fees prescribed in amendments to this rule as well as new legal fees prescribed herein shall pertain to the Judiciary Development Fund as established by law. The persons herein authorized to collect legal fees shall be accountable officers and shall be required to post bond in such amount as prescribed by law. Law. Section 4. Clerks of the Court of Appeals and of the Supreme Court. A. For filing an action, proceeding, appeal by notice or record on appeal when required, entering appearance of the parties, entering orders of the court, filing and docketing all motions, docketing of case on all proper dockets, and indexing the same, entering, recording and certification of judgment and remanding of records of the lower court, taxing the costs, administering all necessary oaths or affirmation in the action or proceeding, recording the opinion of the court, and issuing all necessary process in the action or proceeding not herein otherwise provided for, each action or special proceeding, 500, p. 500.00, pesos. B. For the performance of marriage ceremony, including issuance of certificate of marriage, 300, p. 300.00, pesos. C. For furnishing transcripts of the record or copies of any record, judgment, or entry of which any person is entitled to demand and receive a copy, for each page, 4, p. 4.00, pesos. D. For each certificate not in process, 30, p. 30.00, pesos. E. For every search for anything above a year's standing and reading the same, 15, p. 15.00, pesos. F. For a commission on all money coming into his hands, rules or order of the court and caring for the same, 2 1/2, 2.5%, on all sums not exceeding 4,000, p. 4,000.00, pesos, and 1 1/2, 1.5%, upon all sums in excess of 4,000, p. 4,000.0, pesos, and 1% on all sums in excess of 40,000, p. 40,000.00, pesos. 4a. Section 5. Fees to be paid by the advancing party. The fees of the clerk of the Court of Appeals or of the Supreme Court shall be paid him at the same time of the entry of the action or proceeding in the court by the party who enters the same by appeal or otherwise, and the clerk shall in all cases give a receipt for the same and shall enter the amount received upon his book, specifying the date when received, person from whom received, name of action in which received and amount received. If the fees are not paid, the court may refuse to proceed with the action until they are paid and may dismiss the appeal or the proceeding. 3a. Section 6. Fees of bar candidates. A. For filing the application for admission to the bar, whether admitted to the examination or not, 1,750, p. 1,750.00, pesos for new applicants, and for repeaters, plus the additional amount of 200, p. 200.00, pesos multiplied by the number of times the applicant has failed in the bar examinations. B. For admission to the bar, including oath-taking, signing of the roll of attorneys, the issuance of diploma of admission to the Philippine bar, 1,750, p. 1,750.00, pesos. C. Other bar fees. For the issuance of 1. Certification of admission to the Philippine bar, p. 50.00. 2. Certificate of good standing, local, 50.00. 3. Certificate of good standing, foreign, 100.00. 4. Verification of membership in the bar, 50.00. 5. Certificate of grades in the bar examinations, 50.00. 6. Other certification of records at the bar office, per page, 15.00. 7. A duplicate diploma of admission to the Philippine bar, 500.00. 4. Services in connection with the return of examination notebooks to examinees, a fee of 30, p. 30.00, pesos shall also be charged. 6a. Section 7. Clerks of Regional Trial Courts. A. For filing an action or a permissive counterclaim or money claim against an estate not based on judgment, or for filing with leave of court a third party, fourth party, etc., complaint, or a complaint in intervention, and for all clerical services in the same, if the total sum claimed, exclusive of interest, or the stated value of the property in litigation, is 1 less than p. 100,000.00 p. 500.00. 2 p. 100,000.00 or more but less than p. 150,000.00 p. 800.00. 3 p. 150,000.00 or more but less than p. 200,000.00 p. 1,000.00. 4 p. 200,000.00 or more but less than p. 250,000.00 p. 1,500.00. 5 p. 250,000.00 or more but less than p. 300,000.00 p. 1,750.00. 6 p. 300,000.00 or more but less than p. 350,000.00 p. 2,000.00. 7 p. 350,000.00 or more but not more than p. 400,000.00 p. 2,250.00. 8 for each P1,000.00 in excess of 400,000.00 P10.00. B. For filing. 1. Actions where the value of the subject matter cannot be estimated P600.00. 2. Special civil actions except judicial foreclosure of mortgage which shall be governed by paragraph A, above 600.00. 3. All other actions not involving property 600.00. In a real action, the assessed value of the property, or if there is none, the estimated value thereof shall be alleged by the claimant and shall be the basis in computing the fees. C. For filing requests for extrajudicial foreclosure of real estate or chattel mortgage, if the amount of indebtedness, or the mortgagee's claim is 1 less than P50,000.00 P275.00, 2 P50,000.00 or more but less than P100,000.00 P400.00, 3 P100,000.00 or more but less than P150,000.00 P500.00, 4 P150,000.00 or more but less than P200,000.00 P650.00, 5 P200,000.00 or more but less than P250,000.00 P1,000.00, 6 P250,000.00 or more but less than P300,000.00 P1,250.00, 7 P300,000.00 or more than but less than P400,000.00 P1,500.00, 8 P400,000.00 or more but less than P500,000.00 P1,750.00, 9 P500,000.00 or more but not less than P1,000,000.00 P2,000.00, 10 for each P1,000.00 in excess of P1,000,000.00 P10.00. D. For initiating proceedings for the allowances of wills, granting letters of administration, appointment of guardians, trustees, and other special proceedings, the fees payable shall be collected in accordance with the value of the property involved in the proceedings, which must be stated in the application or petition, as follows. 1 more than P100,000.00 but less than P150,000.00 P2,000.00, 2 P150,000.00 or more but less than P200,000.00 2,250.00, 3 P200,000.00 or more but less than P250,000.00 2,500.00, 4 P250,000.00 or more but less than P300,000.00 2,750.00, 5 P300,000.00 or more but less than P350,000.00 3,000.00, 6 P350,000.00 or more but not more than P400,000.00 3,250.00, 7 for each P1,000.00 in excess of P400,000.00 10.00. If the value of the estate as definitely appraised by the court is more than the value declared in the application, the difference of fee shall be paid, provided that a certificate from the clerk of court that the proper fees have been paid shall be required prior to the closure of the proceedings. E. For filing petitions for naturalization or other modes of acquisition of citizenship, 2000 P2,000.00 pesos. F. for filing petitions for adoption, support, annulment of marriage, legal separation, and other actions or proceedings under the Family Code, 200, p. 200.00, pesos. If the proceedings involve separation of property, an additional fee corresponding to the value of the property involved shall be collected, computed in accordance with the rates for special proceedings. G. For all other special proceedings not concerning property, 200, p. 200.00, pesos. H. For the performance of the marriage ceremony including issuance of certificate of marriage, 300, p. 300.00, pesos. I. For filing an application for commission as notary public, 500, p. 500.00, pesos. J. For certified copies of any paper, record, decree, judgment, or entry thereof for each page, 4, p. 4.00, and 15, p. 15.00, pesos for certification. K. For a commission on all money coming into the clerk's hands by law, rule, order, or writ of court and caring for the same, 1 1/2, 1.5%, percentum on all sums not exceeding 40,000, p. 40,000.00, pesos, and 1%, percentum on all sums in excess of 40,000, p. 40,000.00, pesos. L. For any other services as clerk not provided in the section, 150, p. 150.00, pesos shall be collected. 7a. Section 8. Clerks of courts of the first level. A. For each civil action or proceeding, where the value of the subject matter involved, or the amount of the demand, inclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs is 1. Not more than p. 20,000.00, p. 150.00. 2. More than p. 20,000.00 but not more than p. 100,000.00 500.00. 3. More than p. 100,000.00 but not more than p. 200,000.00 1250.00. 4. More than p. 200,000.00 but not more than p. 300,000.00 1750.00. 5. More than p. 300,000.00 but not more than p. 400,000.00 2500.00. In a real action, other than for forcible entry and unlawful detainer, the assessed value of the property, or if not declared for taxation purposes, the assessed value of the adjacent lots, or if there is none, the estimated value thereof shall be alleged by the claimant and shall be the basis in computing the fees. B. For initiating proceedings for the allowance of wills, granting of letters of administration and settlement of estates of small value, where the value of the estate is 1. Not more than p. 20,000.00, p. 250.00. 2. More than p. 20,000.00 but not more than p. 100,000.00 1350.00. 3. More than p. 100,000.00 but not more than p. 200,000.00 2000.00. 4. For each proceeding other than the allowance of wills, probate, granting of letters of administration, settlement of estate of small value, 200, p. 200.00, pesos. C. For forcible entry and unlawful detainer cases, 150, p. 150.00, pesos. D. For appeals in all actions or proceedings, including forcible entry and detainer cases, taken from courts of first level, 200, p. 200.00, pesos. E. For the performance of marriage ceremony, including issuance of certificate of marriage, 300, p. 300.00, pesos. F. for taking affidavit, 25, p 25.00, pesos. G, for taking acknowledgement, 30, p 30.00, pesos. H, for taking and certifying depositions, including oath, per page, 8, p 8.00, pesos. I, for certified copies of any record, per page, 10, p 10.00, pesos. J, for stamping and registering books as required by Articles 19 and 36 of the Code of Commerce, each book, 30, p 30.00, pesos. K, for performing notarial acts for which fees are not specifically fixed in this section, the same fees which notaries public are entitled to receive, 8a. Section 9. Sheriffs and other persons serving processes. A, for serving summons and copy of complaint, for each defendant, 60, p 60.00, pesos. B, for serving subpoenas in civil action or proceeding, for each witness to be served, 24, p 24.00, pesos. C, for executing a writ of attachment against the property of defendant, 60, p 60.00, pesos. D, for serving temporary restraining order, or writ of injunction, preliminary or final, of any court, 60, p 60.00, pesos. E, for executing a writ of replevin, 60, p 60.00, pesos. F, for filing bonds or other instruments of indemnity or security in provisional remedies, for each bond or instrument, 50, p 50.00, pesos. G, for executing a writ or process to place a party in possession of the real estates, 150, p 150.00, pesos. H, for advertising a sale, besides cost of publication, 75, p 75.00, pesos. I, for taking inventory of goods levied upon when the inventory is ordered by the court, 150, p 150.00, pesos per day of actual inventory work. J, for levying on execution on personal or real property, 75, p 75.00, pesos. K, for issuing a notice of garnishment, for each notice, 30, p 30.00, pesos. L, for money collected by him by order, execution, attachment, or any other process, judicial or extrajudicial, the following sums, to wit. 1 on the first 4,000, p 4,000.00, pesos, 5, 5%, percentum. 2 on all sums in excess of 4,000, p 4,000.00, pesos, 2 1/2, 2.5%, percentum. In addition to the fees hereinabove fixed, the party requesting the process of any court, preliminary, incidental, or final, shall pay the sheriff's expenses in serving or executing the process, or safeguarding the property levied upon, attached or seized, including kilometerage for each kilometer of travel, guards fees, warehousing, and similar charges, in an amount estimated by the sheriff, subject to the approval of the court. Upon approval of said estimated expenses, the interested party shall deposit such amount with the clerk of court and ex officio sheriff, who shall disperse the same to the deputy sheriff assigned to effect the process, subject to liquidation within the same period for rendering a return on the process. Any unspent amount shall be refunded to the party making the deposit. A full report shall be submitted by the deputy sheriff assigned with his return, and the sheriff's expenses shall be taxed as costs against the judgment debtor. 9a. Section 10. Stenographers. Stenographers shall give certified transcript of notes taken by them to every person requesting the same upon payment of a. 6, p 6.00, pesos for each page not less than 250 words before the appeal is taken, and b. 3 pesos and 60 centavos, p 3.60, for the same page, after the filing of the appeal, provided, however, that 1/3 of the total charges shall be paid to the court and the remaining 2/3 to the stenographer concerned. 10a. Section 11. Notaries. No notary public shall charge or receive for any service rendered by him any fee, remuneration, or compensation in excess of those expressly prescribed in the following schedule. A. For protests of drafts, bills or exchange, or promissory notes for non-acceptance or non-payment and for notice thereof, 36, p. 36.00, pesos. B. For the registration of such protest and safekeeping of the same, 36, p. 36.00, pesos. C. For authenticating powers of attorney, 36, p. 36.00, pesos. D. For sworn statement concerning correctness of any account or other document, 36, p. 36.00, pesos. E. For each oath of affirmation, 36, p. 36.00, pesos. F. For receiving evidence of indebtedness to be sent outside, 36, p. 36.00, pesos. G. For issuing a certified copy of all or part of his notarial register or notarial records, for each page, 36, p. 36.00, pesos. H. For taking depositions, for each page, 36, p. 36.00, pesos, and I. For acknowledging other documents not enumerated in this section, 36, p. 36.00, pesos. 11a. Section 12. Other officers taking depositions. Other officers taking depositions shall receive the same compensation as above, provided for notaries public for taking and certifying depositions. 10. Section 13. Witness fees. A. Witnesses in the Supreme Court, in the Court of Appeals and in the regional trial courts, either in actions or special proceedings, shall be entitled to 100, p. 100.00, pesos per day inclusive of travel time. B. Witnesses before courts of the first level shall be allowed 50, p. 50.00, pesos per day. C. Fees to which witnesses may be entitled in a civil action shall be allowed, on a certification of the clerk of court or judge of his appearance in the case. A witness shall not be allowed compensation for his attendance in more than one case or more than one side of the same case at the same time, but may elect in which of several cases or on which side of a case, when he is summoned by both sides, to claim his attendance. A person who is compelled to attend court on other business shall not be paid as witness. 11a. Section 14. Fees of appraisers. Appraisers appointed to appraise the estate of a ward of a deceased person shall each receive a compensation of 200, p. 200.00, pesos per day for the time actually and necessarily employed in the performance of their duties and in making their reports, which fees, in each instance, shall be paid out of the estate of the ward or deceased person, as the case may be. Any actual and necessary traveling expenses incurred in the performance of their duties of such appraisers may likewise be allowed and paid out of the estate. 12a. Section 15. Fees of commissioners in eminent domain proceedings. The commissioners appointed to appraise lands sought to be condemned for public uses in accordance with these rules shall each receive a compensation of 200, p. 200.00, pesos per day for the time actually and necessarily employed in the performance of their duties and in making their report to the court, which fees shall be taxed as part of the costs of the proceedings. 13a. Section 16. Fees of commissioners in proceedings for partition of real estate. The commissioners appointed to make partition of real estate shall each receive a compensation of 200, p. 200.00, pesos per day for the time actually and necessarily employed in the performance of their duties and in making their report to the court, which fees shall be taxed as a part of the costs of the proceedings. 14a. Section 17. Fees, and the account thereof. The clerk, under the direction of the judge, shall keep a book in which shall be entered the items of fees which have accrued for the transaction of businesses covered by the provisions of this rule, for which fees are payable, specifying for what business each time of fees has accrued. Receipts shall be given for all fees received, and they shall be accounted for in the manner provided in relation to the fees of clerks of courts in actions. The book of fees kept by the clerk shall be accounted for in the manner provided in relation of the fees of the clerk of court in inspection of auditing officer and other interested therein. 15. Section 18. Indigent litigants exempts from payment of legal fees. Indigent litigants, a, whose gross income and that of their immediate family do not exceed 4,000, P4,000.00 pesos a month if residing in Metro Manila, and 3,000, P3,000.00 pesos a month if residing outside Metro Manila, and, b, who do not own real property with an assessed value of more than 50,000, P50,000.00 pesos shall be exempt from the payment of legal fees. The legal fees shall be a lien on any judgment rendered in the case favorably to the indigent litigant, unless the court otherwise provides. To be entitled to the exemption herein provided, the litigant shall execute an affidavit that he and his immediate family do not earn a gross income above mentioned, nor they own any real property with the assessed value aforementioned, supported by an affidavit of a disinterested person attesting to the truth of the litigant's affidavit. Any falsity in the affidavit of a litigant or disinterested person shall be sufficient cause to strike out the pleading of that party, without prejudice to whatever criminal liability may have been incurred. 16a. Section 19. In addition to the fees imposed in the preceding sections, a victim compensation fee of 5, P5.00 pesos pursuant to Rep. Act. Number 7309 shall be assessed and collected for the filing of every complaint or petition initiating an ordinary civil action, special civil action or special proceeding in the trial courts, including civil actions impliedly instituted with criminal actions under Rule 111, Revised Rules of Criminal Procedure, where a filing fee is likewise collected. All sums collected shall be remitted to the Department of Justice every quarter by the clerk of court concerned. 18a. Section 20. Other fees. The following fees shall also be collected by the clerks of regional trial courts or courts of the first level, as the case may be. A. In estafa cases where the offended party fails to manifest within 15 days following the filing of the information that the civil liability arising from the crime has been or would be separated prosecuted. 1 less than P100,000.00 P500.00 2 P100,000.00 or more but less than P150,000.00 P800.00 3 P150,000.00 or more but less than P200,000.00 P1,000.00 4 P200,000.00 or more but less than P250,000.00 P1,500.00 5 P250,000.00 or more but less than P300,000.00 P1,750.00 6 P300,000.00 or more but less than P350,000.00 P2,000.00 7 P350,000.00 or more but no more than P400,000.00 P2,250.00 8 for each P1,000.00 in excess of P400,000.00 P10.00 b. For motions for postponement after completion of the pre-trial stage, 100 pesos, P100.00, for the first, and an additional 50 pesos, P50.00, for every postponement thereafter based on that for the immediately preceding motion, provided, however, that no fee shall be imposed when the motion is found to be based on justifiable and compelling reason. c. For bonds by sureties in criminal and civil cases, 300 pesos, p. 300.00. d. For applications for and entries of certificates of sale and final deeds of sale in extrajudicial foreclosures of mortgages, 300, p. 300.00, pesos. e. For applications for and certificates of sale in notarial foreclosures. 1 on the first 4,000, p. 4,000.00, pesos, 5%, percent. 2 on all sums in excess of 4,000, p. 4,000.00, pesos, 2½ 2.5%, AM No 99-8-01 SC, September 14, 1999. Section 21. Government exempt. The Republic of the Philippines, its agencies, and instrumentalities, are exempt from paying the legal fees provided in this rule. Local governments, and government-owned or controlled corporations with or without independent charters are not exempt from paying such fees. 19. This resolution shall take effect on the first day of March, 2000, and shall be published in two newspapers of general circulation not later than the 15th of February 2000. Rule 142. Cost. Section 1. Cost ordinarily follow results of suit. Unless otherwise provided in these rules, cost shall be allowed to the prevailing party as a matter of course, but the court shall have power, for special reasons, to adjudge that either party shall pay the costs of an action, or that the same be divided, as may be equitable. No costs shall be allowed against the Republic of the Philippines unless otherwise provided by law. Section 2. When action or appeal dismissed. If an action or appeal is dismissed for want of jurisdiction or otherwise, the court nevertheless shall have the power to render judgment for cost, as justice may require. Section 3. Cost when appeal frivolous. Where an action or appeal is found to be frivolous, double or treble cost may be imposed on the plaintiff or appellant, which shall be paid by his attorney, if so ordered by the court. Section 4. False allegations. An averment in a pleading made without reasonable cause and found untrue shall subject the offending party to the payment of such reasonable expenses as may have been necessarily incurred by the other party by reason of such untrue pleading. The amount of expenses so payable shall be fixed by the judge in the trial, and taxed as costs. Section 5. No cost for irrelevant matters. When the record contains any unnecessary, irrelevant, or immaterial matter, the party as whose instance the same was inserted or at whose instance the same was printed, shall not be allowed as costs any disbursement for preparing, certifying, or printing such matter. Section 6. Attorney's fees as cost. No attorney's fees shall be taxed as costs against the adverse party, except as provided by the rules of civil law. But this section shall have no relation to the fees to be charged by an attorney as against his client. Section 7. Restriction of cost. If the plaintiff in any action shall recover a sum not exceeding 10 pesos as debt or damages, he shall recover no more cost than debt or damages, unless the court shall certify that the action involved a substantial and important right to the plaintiff, in which case full cost may be allowed. Section 8. Costs, how to taxed. In inferior courts, the costs shall be taxed by the justice of the peace or municipal judge and included the judgment. In superior courts, costs shall be taxed by the clerk of the corresponding court on 5 days written notice giving by the prevailing party to the adverse party. With this notice shall be served a statement of the items of the cost claimed by the prevailing party, verified by his oath or that of his attorney. Objections to the taxation shall be made in writing, specifying the items objected to. Either party may appeal to the court from the clerk's taxation. The costs shall be inserted in the judgment if taxed before its entry, and payment thereof shall be enforced by execution. Section 9. Cost in justice of the peace or municipal courts. In an action or proceeding pending before a justice of the peace or municipal judge, the prevailing party may recover the following cost, and no other. A. For the complaint or answer, 2 pesos. B. For the attendance of himself, or his counsel, or both, on the day of trial, 5 pesos. C. For each additional day's attendance required in the actual trial of the case, 1 peso. D. For each witness produced by him, for each day's necessary attendance at the trial, 1 peso, and his lawful traveling fees. E. For each deposition lawfully taken by him and produced in evidence, 5 pesos. F. For original documents, deeds, or papers of any kind produced by him, nothing. G. For official copies of such documents, deeds, or papers, the lawful fees necessarily paid for obtaining such copies. H. The lawful fees paid by him for service of the summons and other process in the action. I. The lawful fees charged against him by the judge of the court in entering and docketing and trying the action or proceeding. Section 10. Cost in court of first instance. In an action or proceeding pending in a court of first instance, the prevailing party may recover the following costs, and no other. A. For the complaint or answer, 15 pesos. B. For his own attendance, and that of his attorney, down to and including final judgment, 20 pesos. C. For each witness necessarily produced by him, for each day's necessary attendance of such witness at the trial, 2 pesos, and his lawful traveling fees. D. For each deposition lawfully taken by him, and produced in evidence, 5 pesos. E. For original documents, deeds, or papers of any kind produced by him, nothing. F. For official copies of such documents, deeds, or papers, the lawful fees necessarily paid for obtaining such copies. G. The lawful fees paid by him in entering and docketing the action or recording the proceedings, for the service of any process in action, and all lawful clerk's fees paid by him. Section 11. Costs in Court of Appeals and in Supreme Court. In an action or proceeding pending in the Court of Appeals or in the Supreme Court, the prevailing party may recover the following costs, and no other. A. For his own attendance, and that of his attorney, down to and including final judgment, 30 pesos in the Court of Appeals and 50 pesos in the Supreme Court. B. For official copies of record on appeal and the printing thereof, and all other copies required by the rules of court, the sum actually paid for the same. C. All lawful fees charged against him by the clerk of the Court of Appeals or of the Supreme Court, in entering and docketing the action and recording the proceedings and judgment therein and for the issuing of all process. D. No allowance shall be made to the prevailing party in the Supreme Court or Court of Appeals for the brief or written or printed arguments of his attorney, or copies thereof, aside from the 30 or 50 pesos above stated. E. If testimony is received in the Supreme Court or Court of Appeals not taken in another court and transmitted thereto, the prevailing party shall be allowed the same cost for witness fees, depositors, and process and service thereof as he would have been allowed for such items had the testimony been introduced in a court of first instance. F. The lawful fees of a commissioner in an action may also be taxed against the defeated party, or apportioned as justice requires. Section 12. Costs when witness fails to appear. If a witness fails to appear at the time and place specified in the subpoena issued by any inferior court, the cost of the warrant of arrest and of the arrest of the witness shall be paid by the witness if the court shall determine that his failure to answer the subpoena was willful or without just excuse. Section 13. Costs when the person cited for examination in probate proceedings. When a person is cited, on motion of another, to appear before the court to be examined in probate proceedings, the court may, in its discretion, tax costs for the person so cited and issue execution therefor, allowing the same fees as for witnesses in courts of first instance. Rule 143. Applicability of the rules. These rules shall not apply to land registration, cadastral and election cases, naturalization and insolvency proceedings, and other cases not herein provided for, except by analogy or in a suppletory character and whenever practicable and convenient. The Lawful Project, Ariano Law Foundation. Rule 144. Effectiveness. These rooks shall take effect on January 1, 1964. They shall govern all cases brought after they take effect, and also all further proceedings in cases then pending. Except to the extent that in the opinion of the court their application would not be feasible or would work injustice, in which event the former procedure shall apply.